This is Judge Herb Dodell. We're going to talk about some interesting things over the next few weeks as we make more of these YouTubes. But many of them will deal with subjects that are not really of significance in your lives, may never happen, but they'll be interesting. And you never know. And the reason we use a lot of these cases as illustrations is because if it happened to someone else, it could happen to you. Just like today, it might not make any difference about getting arrested for drunk driving or getting evicted or small claims or anything like that, but you never know when it will happen. At least you'll have something interesting. So today, I'm going to talk about something that'll definitely be interesting if you've been convicted of any kind of crime. And that is, what do you do about the record? There's a record. It says conviction. Is there anything you can do about it? The answer is, in California, yes. It is section 1203.4 of the California Penal Code, and it says basically, and I'm just giving you basics, and again, this is California law, at the end of your probation, if you complete the probation, and that includes paying fines, restitution, and anything else, you can petition the court on a simple form. You don't even need a lawyer, where you ask for the court to either reduce a felony to a misdemeanor, or if it was a misdemeanor, to dismiss the case by removing your plea and any verdict that may have been found. And that will eliminate the record showing a conviction. Does that mean that you can say no when you're asked a question, have you ever been convicted before? No, you're supposed to answer the question, but what it will show, and people refer to this sometimes as exculpatory or an expungement, but it's really not that. What the record will show is that the conviction was basically dismissed. And that's very important. Will it make any difference if you have a driving under the influence conviction? No, it won't. Will it matter if you've been convicted of certain felonies? No, it won't. That's why it's absolutely essential that if you enter into any kind of plea agreement, any plea bargain it's called, I don't know if it's such a bargain, but they call it a plea bargain, you have to make sure that what you're pleading to is one of those offenses that can be later dismissed upon petition. Now, if you have not yet completed your probation, you can request the court to accentuate, or actually accelerate, I meant to say, the date for the completion of the probation so that you can make the motion. You want to make sure that you're able to pay the restitution or the fine, because you do have to satisfy all the conditions. And if you're not on probation, you still can make that petition. Generally, in California, they apply a 1-year standard, and you can make that request at the end of 1 year. This is significant because it will show that the case was ultimately dismissed. Again, just go online. It's section 1203.4 of the California Penal Code. Very important you do it to keep your record clean.